The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to explain how to follow the proper corporate formalities to maintain your S-Corp. So let's first talk about why we care about corporate formalities before we dive into what they are. An S-Corp provides certain benefits over a sole proprietorship that include liability protection. So if someone sues the corporation, they can't get to the shareholders' personal assets if corporate formalities are properly maintained. There's also tax benefits, so you can save on self-employment tax at the very least by incorporating. The issue is that a lot of people will incorporate by filing their articles of incorporation with the Secretary of State and think they're done. That's fine as long as nothing ever goes wrong, as long as they never get audited or sued. But the problem is that if they get audited or sued and they haven't been following the corporate formalities that we're about to talk about, the other side of the lawsuit can do something called pierce the corporate veil, which means that they can say you weren't really maintaining this as a true corporation. It was just kind of a sham or a shell, and therefore, even though you were incorporated with the Secretary of State, we're going to attribute personal liability to you. So what a lot of people don't understand is incorporating isn't enough. You have to actually go through the motions that are required to act as a corporation in order to maintain the liability protection that the corporation gives you, and potentially in order to avoid being audited and having to pay personal taxes back to the government. So let's talk about what those corporate formalities are. So most people know about filing articles of incorporation with the Secretary of State. This is how you tell the Secretary of State that you exist as a corporation. It's a pretty simple process. There's a form that you can get on the Secretary of State's website, and you pay some money and you can tell the Secretary of State you're incorporated. That's where a lot of people stop. It's important to follow these other steps, though. The second is to draft bylaws. So even if you are just a sole proprietorship and you're the only person involved in your corporation, you need bylaws in order to basically get the liability protection and tax benefits you want out of the corporation if your corporation is ever challenged. If you're a sole proprietorship, bylaws are a very simple document giving you ultimate power within the corporation. If you've got multiple partners, it's much more important to have bylaws because these are basically the rules of the game that the directors and shareholders and officers have to play by. It's your essentially partnership agreement for everybody involved in the corporation. Once you've drafted your bylaws, you should have an initial meeting of the shareholders. This is basically, you do a couple things here. You ratify the bylaws and you appoint who the board of directors are going to be. Again, even if it's only one person, you're going to want to appoint yourself as a director. You will, if it's not a sole proprietorship or a tightly knit group, you'll have to give notice to all of the shareholders, and there's certain notice procedures you have to follow to give notice to the shareholders. If you are a tightly knit group or just one person, you can waive notice of all of these shareholder and director meetings we're about to talk about. So along with the initial meeting of shareholders, you will do an initial meeting of directors. And at the initial meeting of directors, once the directors have been appointed, that's where you appoint who your officers are, your president, vice president, secretary, and treasurer. And you can have multiple vice presidents. You don't have to appoint all the officer positions. But this is, once you've got your articles of incorporation, your bylaws, and your initial meeting minutes done, this is the basic corporate setup to be up and running and doing business as a corporation. Now, there's some other things you've got to do here. You need to create a stock ledger, and a stock ledger is basically something that keeps track of all of the shares that have been issued and the transfer of those shares between people. It also keeps track of the names and addresses and percentage ownership of all of the shareholders. You'll also have to issue stock certificates. So these are basically, it's very simple. It's almost like a check. It's a legal piece of paper signifying a certain number of shares have been transferred to a particular person. And you'll keep copies or originals of the stock certificates and the stock ledger and all of the meeting minutes and the bylaws in something called a corporate book. This is probably the least important thing. The corporate book is just something that houses all of your documents. If you don't have a formal, nicely bound corporate book, that's not going to have any legal significance, but it's just a good place to keep track of all your documents. And there's companies that sell corporate books that will have tabs for each of the different types of minutes and documents that you're going to need. So once you've done all of these things and put them together in your corporate book, you've done what you really need to do to set up the corporation. Then it just comes down to annual maintenance. So every year you'll have to file an annual report with the Secretary of State and pay a fee to the Secretary of State. This is mostly the biggest part about the report is paying the fee. It's not, again, terribly complicated to put together, but the Secretary of State will want basic information about the corporation. You'll do an annual meeting of the shareholders and directors. And again, anytime we do a meeting, if it's just one person, then your attorney will just prepare all the forms and you'll sign some documents. You don't have to sit and have a meeting with yourself, but you have to have the documents in your corporate book in order to maintain corporate formalities. If it's a couple people, you can still probably just have your attorney draw up some standard documents and everybody signs off on it and signs off that the meeting happened. You don't necessarily, in a small corporation, have to issue notice and hold these meetings. You just need to have the documentation prepared. As necessary throughout the course of running the business, you need to have special meetings of shareholders. Now, this will very, very rarely happen if you are a single shareholder corporation, but if there's a couple of you, there's certain things that your bylaws will say require a vote of the shareholders, and this is where you will have special meetings accomplished, or you will have basically just special meeting minutes drawn up by your attorney to effectuate whatever change you want to effectuate. So these are major changes within the corporation. So if you're trying to change the name or change the type of entity, usually the Secretary of State or whoever you're dealing with will require evidence that a special meeting has occurred. Finally, as you're going through the running of your corporation, you have to just follow the bylaws with how decision-making is supposed to be accomplished. So certain types of decisions will require a vote of shareholders or a vote of directors or a 2/3 vote of either of those groups, or it might just require consent in writing of one of the stakeholder groups. Other decisions might be the directors making them on their own without, just as their managerial discretion, without needing any consent from anybody or meetings to be held. So it's important that you understand what the rules of the game you're playing are and follow those rules when operating your business. If you're a single shareholder S Corp, your attorney should draw up bylaws that give you the widest managerial discretion to make any decisions necessary without having to have special meetings or having to obtain consent from yourself. Because I know it sounds ridiculous, but again, the end product is if you are ever sued and someone's in a deposition and they ask to see your corporate book, you can hand over a full book that has every year annual meeting minutes accomplished. It has all the proper setup done so that no one can pierce the corporate veil and take personal liability to you. Because it's a shame when people are paying a setup fee to an attorney and to the Secretary of State and paying annual fees to the Secretary of State if they're not doing all the work that they need to do to actually make their corporation protect them. That ends up just being a waste of money. So if you have any questions, please leave a comment in our comment section below this post at learn-about-law.com. Feel free to give us a call at 630-324-6666. That's 630-324-6666 if you'd like to schedule a free consultation. We offer free consultations in nearly every area of law, and we have offices all around Chicagoland for your convenience. If you found this helpful, please subscribe to us on iTunes, YouTube, and SoundCloud. And thank you so much for listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.